allocation for election preparedness and dispute resolution will be pivotal in translating this plan into impact. I equally acknowledge the critical role of civil society organizations, our development partners, many of whom have walked this journey with us. Your technical expertise, your catalytic funding, and your enduring belief in Kenya's democratic promise have strengthened our institutional frameworks. We do not take this partnership for granted, and we invite you to continue working with us. Let me take this opportunity to express sincere appreciation to the outgoing JSC members. You have served with distinction and integrity, and your legacy is imprinted in every paragraph of this plan. To the incoming committee, I extend my warmest congratulations and best wishes. The path ahead is demanding, but you will walk it with the confidence of a judiciary committed to transformation, independence, and service. As the Office of the Chief Registrar, I reaffirm our full and sustained support for the work of the committee. We are committed to creating the operational, administrative, and financial conditions necessary for the JSC to succeed, not just in 2027, but in every election and beyond it. As I conclude, allow me to underscore one truth. Credible elections are not the work of a single institution. They are the product of a shared vision, shared responsibility, and shared accountability. And the judiciary stands ready not just to adjudicate disputes, but to defend the soul of our democracy. Thank you, and may we continue to serve Kenya with diligence, courage, and foresight. God bless you.
Thank you very much, Honorable CRJ, indeed, for highlighting that in order to implement the operational plan successfully, we will need $1 billion shillings. And with the current allocation of 15 million, that is only 1.5%. But I am sure that Honorable Stephen Mogaka will affirm that the judiciary indeed will receive its 3% allocation of the national budget to fully cover for this process. It is now my pleasure to welcome Honorable Stephen Mogaka, Member of Parliament representing West Mugirango, and a member of JLAC representing the Honorable Chairperson, Honorable Gitonga Mulugara, to give us the remarks. We thank you, and we truly are honored to have you join us.
Your Ladyship, the Chief Justice, the judges of the Supreme Court, Mheshimiwa Chairman JLAC, all protocols as previously laid being observed, I say good morning. Good morning, one more. Thank you very much. My job is that of a messenger to deliver a statement by my chair, the Honorable George Gitonga Mulugara, who also tenders his apology for not being able to be with us today because he's engaged at the ground. He sends warm greetings, and as a member of JLAC, I want to assure the CRJ and the judiciary at large that the judiciary has received unprecedented support by the 13th Parliament, and that 13th Parliament is the same with the two remaining budgets, and it is the Parliament that wants Kenya to succeed. And you therefore rest assured that as it has been done before, so it will be done going forward. Permit me now to read Honorable Mulugara's remarks. The official launch of the Judiciary Committee on Elections Operational Plan 2025-2028 is a significant milestone, not only for the judiciary as an institution, but for the entire nation, to lay the groundwork for a credible, peaceful, and legitimate electoral process in the next cycle. The conduct of the first general election under the Constitution of Kenya 2010 was informed by historical challenges as well as the tragic events surrounding the 2007-2008 post-election violence, which was partly caused by the loss of public confidence in the judiciary to determine electoral disputes. It was therefore imperative to develop a structured and efficient electoral dispute resolution mechanism. On the role of EDR, the judiciary is a critical pillar in ensuring the integrity of the electoral process and the legitimacy of democracy and governance. The Constitution accords the judiciary, including courts and tribunals, the mandate to resolve electoral disputes. As part of broader judicial reforms, in anticipation of the 2013 general elections, the judiciary established the Judiciary Working Committee on Election Preparations to develop a program for building judicial capacity on electoral matters and coordinating with relevant stakeholders. Whereas elections are held every 5 years, the manner in which electoral disputes are addressed has a lasting impact on public perception of the judiciary's credibility and integrity. Recognizing this reality and informed by the experiences drawn from the 2013 general election, the Honorable Chief Justice in August 2015 established the Judicial Committee on Elections as the permanent successor of the JWCEP. The JCE was constituted as a standing committee of the judiciary with a broad and clear mandate to ensure institutional preparedness for electoral dispute resolution. Its core responsibilities, as directed upon formation, included to advise the judiciary, to develop and implement in conjunction with the judiciary a training institute, training programs for the efficient and effective management of election disputes for judicial officers and support staff. It also was intended to develop and design a system for monitoring and evaluating the management and administration of election-related disputes in court, as well as to liaise and coordinate with stakeholders to ensure efficient, effective, timely resolution of elections-related disputes and offences. It also was meant to advise the judiciary on the information that needs to be developed and disseminated to the public on the avenues open to it to pursue electoral disputes and approaches that will be employed. In furtherance of good governance and streamlined decision-making, the JCE has discharged its mandate through the following subcommittees: the Finance and Administration Committee, the Law Reform and Stakeholder Engagement, as well as the Capacity Building Committee. In line with the constitutional mandate and recognizing its role within the broader electoral ecosystem, the judiciary actively participated in the National Sectoral Consultative Forum on Election Preparedness in 2022, with the objective of enhancing interagency coordination and ensuring the conduct of peaceful, credible, and transparent elections. The judiciary's collaboration in this regard included capacity building, election security, political party engagement, peace initiatives, ICT infrastructure development, as well as the development and management of electoral information systems. Throughout the 2022 electoral cycle, JSE spearheaded a comprehensive national capacity building program in collaboration with the Kenya Judiciary Academy and the development partners. It delivered specialized training to 65 judges, 103 magistrates gazetted to handle electoral disputes, and capacity building sessions for deputy registrars, legal researchers, clerks, and personnel from the offices of the principal judge and registrars of high courts and magistrates' courts as well. The trainings and capacity building exercises focused on evidentiary thresholds, the burden and standard of proof in election petitions, scrutiny and recount procedures, interlocutory applications and remedies, and emerging trends in petitions. On the Judiciary Committee on Elections Operations Plan 2025-2028, which is the nucleus of our sitting today, and for which we are extremely grateful, the launch of the Judiciary Committee on Elections Operational Plan 2025-2028 marks an important moment in the evolution of Kenya's election dispute resolution framework. It is both a continuation and a consolidation of the judiciary's deliberate efforts to institutionalize readiness for electoral justice. This plan builds directly from the foundational work of the JWCEP, the sustained initiative of the JCE since 2015, and the strategic insights in the Judiciary Strategic Plan 2016 to 2019. These efforts represent a consistent arc of reform, moving from crisis response to capacity strengthening, and now toward long-term institutional resilience. The Operational Plan 2025-2028 addresses past challenges, closes existing procedural and operational gaps, and reflects the judiciary's evolving understanding of the dynamic electoral environment that we operate in. The plan is anchored in constitutional values and legal principles and aims to ensure the electoral dispute resolution in Kenya is not only timely and efficient, but also trusted and accessible to all. Most importantly, the plan offers pragmatic strategies to streamline election preparedness, refine jurisprudential approaches, leverage technological tools, and strengthen coordination across justice sectors and other institutions. If fully implemented, it will play a transformative role in ensuring that If fully implemented, it will play a transformative role in ensuring that the country continues to enjoy peaceful elections and credible resolutions to electoral disputes as envisioned in our progressive constitution. The Departmental Committee of Justice and Legal Affairs affirms its unwavering support for the Judiciary Committee on Elections Operational Plan 25-28 and the broader work of the JCE. As a committee of the National Assembly tasked with oversight over the justice, legal reform, constitutional affairs, JLAC has remained a consistent partner to the judiciary. It has, in previous electoral cycles, supported the judiciary's budgetary proposals for electoral preparedness and engaged in meaningful consultation with the judiciary in the lead-up to elections, including through national sectoral consultative forums. Furthermore, JLAC remains ready and willing to support legislative proposals that may emanate from the implementation of the Judiciary Committee on Elections Operational Plan 2025-28, particularly those aimed at refining electoral procedures, enhancing judicial efficiency, and promoting access to justice to all Kenyans and actors. As the plan unfolds over the coming years, our committee will continue to work collaboratively with the judiciary to ensure the necessary parliamentary approvals for resource allocation and legal reforms that will anchor these strategies in law as well as policy. A well-resourced and institutionally empowered judiciary is essential in the protection of democracy and the rule of law. For that reason, JLAC will champion the judiciary's electoral preparedness, budgetary needs before the House and support the implementation of all necessary reforms, including those proposed by the JCE to enhance electoral dispute resolution in accordance with the Constitution and the Elections Act. But as we do that, ladies and gentlemen, please also whip our citizens in public participation to also give support to such budgetary allocation, because it is not an exclusive mandate of the legislative arm. In conclusion, my chair says, the launch of the Judiciary Committee on Elections Operational Plan 2025-2028 is not merely ceremonial, but a substantive affirmation of the country's commitment to strengthening electoral justice in Kenya. The Departmental Committee on Justice and Legal Affairs reaffirms its support to the implementation of the plan and its continued partnership with the judiciary in safeguarding the democratic ideals enshrined in our Constitution. May God help us achieve that. God bless you.
Thank you very much for those.
Operation of JCE's Operation Plan 2025-2028. At the center of it is the need to ensure excellence by the courts in handling election disputes and enhance JCE's capacity in developing strategies and interventions that will enhance the institutional election preparedness. Allow me to recall the remarks by the then Chief Justice, the Honorable Dr. Justice Willie Mutunga, when he unveiled the Judiciary Working Committee on Elections Preparations on 10th of May justice is done to all regardless of their status in society. C, the mandate to provide leadership in ensuring that the systems of justice works from start to finish, working closely with other actors in the administration of justice space. And lastly, the mandate to arbitrate electoral disputes. I wish to affirm, Madam Chief Justice, that from where we sit as legislators, the judiciary has done its work very well and has been a key pillar in ensuring the integrity of the electoral process in Kenya. Right from the resolution of disputes arising from political party primaries and nomination of candidates, all the way to the arbitrating highly contested electoral disputes, including the presidential election, the judiciary has been a consistent and dependable safeguard of the Constitution and our electoral system. In this, I have been part and parcel of the team that would say judiciary has done its work well in electoral disputes. One of the things we must celebrate is that by putting the right laws and institutional frameworks in place, including dispute resolution at various stages of the electoral process, we have placed our country on a path of lasting peace and prosperity, where our national fabric is not torn apart on every electoral cycle. Indeed, our stand as a shining beacon in the region for our democratic system and the peaceful transition of power whenever the term of one administration has come to an end and another comes into office. Lady Chief Justice and distinguished guests, our engagement today comes at a time when the Justice, Legal Affairs and Human Rights Committee of the Senate has been working to strengthen its interaction with other actors in the administration of justice, including the Judiciary and the National Council on the Administration of Justice. This is what Madam Ashuga has mentioned, and indeed, just last week we held a high impactful meeting with the Chief Registrar and her team to deliberate on the state of the Judiciary and Administration of Justice report for the year 2023-2024. And as an outcome of that meeting, I will be moving a motion in the Senate later this week to have the Senate debate and adopt the report. Notably, as observed by the Chief Registrar, this will be the first time that the soldier report has been subjected to a substantive consideration by a committee of Parliament, and will also be the first time that the report will be debated in a House of Parliament. This will give the comfort, and this is the assurance I want to give Madam President of the Law Society of Kenya, as well as the Chief Justice and Judiciary, that it will inform and set the pace for a conversation around the challenges that we have as judiciary, both in terms of budgetary allocation that my colleague, Honorable Mugaka, has mentioned, as well as the concerns that Kenyans largely would raise as regards administration of justice in this country. Honorable Chief Justice and distinguished guests, coming back to the issue of elections, one of the key aspirations of my committee has been to ensure that, unlike in the previous elections and cycles, amendments to electoral laws and regulations are concluded in good time ahead of the general election. As you may recall, a key recommendation of the Judicial report was the need for election laws to be enacted at least 2 years before elections. This would not only allow sufficient time for stakeholders' engagement, preparation and implementation, but would also enable adequate capacity building to take place, mitigate the risk of legal challenges, allow more time for public awareness and for the necessary reforms and improvements in the electoral institutions. Just last month, we had a high-level meeting with the Independent Electoral Boundaries Commission, IEBC Secretariat. By then, the commission was not yet in place. Office of the Registrar of Political Parties, ORPP, and civil society organizations, including ELJA, among others, under the umbrella of Uchaguzi platform, to deliberate on priority electoral reform areas ahead of the next general election. We have a follow-up meeting this month, actually next month, where we aim to take stock of the proposals already before Parliament and to agree on the next other proposed amendments to various election laws and regulations. A key voice that has been missing from these conversations is the Judiciary Committee on Elections. Earlier today, I was reviewing some of your reports in preparation for and following previous elections and noted that they contain quite a number of recommendations for policy and legislative reforms arising from your interaction with electoral disputes submitted for resolution before you. I wish to convey and extend our invitation to the chairperson, the incoming chairperson of the JCE, your team, to join us at that meeting so that these proposals can find their way to our committee and to Parliament for consideration and possible amendments in good time. The last issue I wish to comment on is the partnership between JCE and other actors in the electoral space, particularly around electoral dispute resolution. Having been involved in EDR at the political party level and at the political party's dispute resolution, I can confirm that a lot of electoral disputes that find their way to the courts, particularly at the nomination stage, are disputes that need not find their way to the courts. Part of the challenge we have is that of technical capacity of political party officials and members of the political party internal dispute resolution mechanisms on understanding, interpreting, and applying the law and the party rules to resolve these disputes. I wish to request that the JCE, as the subject matter experts and in line with their mandate, partners with the structured capacity building fora for members of political party dispute resolution